Mr. Ray, despite Mr. Trotman's clear and well-presented submissions, we don't feel we need to hear from you. There are two, however, loose ends that we would just wish some assistance on. One is we don't think, although we may be told it's in there somewhere, that we have seen the order of Judge Claire Evans giving leave, or permission, I should say, to appeal.
I have just found it.
Lord Justice Bean has just found it, so that's one of the loose ends. The other is, although this is not necessary for the purpose of our reasoning, when we were exploring with Mr. Trotman the question about whether Rule 310 had in fact been featured in the hearing before Judge Pearce, and he said it hadn't, and you got up to say, not quite as straightforward as that, or words to that effect. We think we ought to just let you explain what you say the position was about that.
I'm grateful, my Lord. It is right that the Rule 310 was not spoken about in those terms. So we didn't have any discussion about what rule was being applied or talked about, or whether, for example, Denton applied. We actually had then a degree of argument about this when we returned following handing down for discussion on costs. And
well, all right. I suppose we better hear the whole story. Yep.
And what? So, if I take the court first.
Well, just give us a summary. I mean, I have indicated that the way in which we propose to decide the case, this is not a point that's important. Otherwise, we would have to obviously hear about it fully. But we just felt we didn't want to have had half the picture. So the first thing you're saying is you accept that it was not discussed as such at the hearing, and therefore, and nor was Denton.
No.
Fine. You were then about to tell us about something that happened at the consequentials hearing. Is that right? Just give us the headline so we can see whether we want to hear about it.
So the headline of it would be this. The argument was made very much in the lines of my skeleton argument for that hearing that the court referred to earlier. So there was reference in that when we went through my skeleton argument.
Sorry, this skeleton argument for what?
For the hearing before His Honour Judge Pearce. So where I
Sorry, I'm at cross purposes. I thought you were telling us about the consequentials hearing.
Yes, sorry.
Were there skeletons for the consequentials hearing? No, I wouldn't have thought so.
Forgive me. There was an application for permission to appeal.
Yes, I imagine there was.
And there were written submissions for that, but I didn't file any.
Yeah. Okay. So what is it?
I think perhaps I jumped ahead. It really depends.
Just give us the headline. What do we need to know in order to have the full picture about 310 at the from the consequentials hearing? A couple of sentences, yes. And then we'll ask you if we need to know more detail.
From the respondent's perspective, there was no detailed discussion of 310 because effectively I made my submissions along the lines.
Sorry, there was no detailed at the consequentials hearing. There was no stuff of 310. Well, why would there be?
No, forgive me. I meant the substantive.
Yeah.
I think if we part the consequentials hearing, the judge explained how he had understood the grounds of appeal and the grounds of response, and said that he concluded that 310 was covered within.
Well, hang on. You're getting ahead of yourself. Why did the question ever come up? Are you suggesting that Mr. Trotman made a complaint that he decided it on the basis of 310?
No.
Right.
No. And so that's why I think perhaps the consequentials was jumping off in the wrong point. The summary, from the response point of view, is that the question of what the court should do if Part 11 applied, and we needed to have brought a claim under Part 11, was covered. So that is the argument that, well, look, you treat it as a Part 11 application. And the focus and the thrust of my submissions at the substantive appeal hearing was the application is made in time, it's effectively the same outcome, it's simply a question of form rather than substance. There wasn't much said in response to that, and the judge then gave his judgment on that basis. In giving his judgment, the judge provides a more detailed analysis than counsel had done in argument.
I'm afraid you misunderstood, Mr. Ria. I just wanted to know factually what was the position, which I think you did answer in your first couple of sentences.
Yes, which is...
And it doesn't sound as though you disagree, Mr. Trotman. Had we regarded this as an important, as a determinative point in the case, you would then make submissions about how it didn't make any difference because, but I'm not, unless my lord and my lady want me to, I'm not going to invite you to make those submissions. No. Well, thank you, Mr. Trotman. Your recollection is confirmed, but as I said, I'm afraid that's not essential to our reasoning. We will not be. You will obviously infer the outcome from what I've just said, but we will deliver. We will not deliver written reasons now. They'll be reserved in the usual way and circulated to counsel for the usual purposes. With two experienced counsel, I don't think I need to go through what those purposes are, but you will be well aware of the Counsel General of Wales case about the limited purposes for which it may be used and therefore the limited purposes for which it may be shown to other people. We will expect the, if possible, an agreed order. If there isn't an agreed order, submissions on the points of difference, which we will then resolve on the papers. I hadn't thought this through, but I think, as I say, although you may infer the outcome, the order will be made on that occasion, not now. Well, it remains to say thanks more, not for want of willingness, I'm sure, Mr. Ray, so much to you, but to you, Mr. Trotman, for your careful and helpful submissions.
All right.